So here's a big question for you. Can a state government ban a part of a gun that's owned by millions and millions of people without stepping on the Second Amendment? That's the exact question at the center of a huge legal fight out of Washington state versus Gator's custom guns. And believe me, the answer could really change the game for gun rights.
And yeah, that question is right at the heart of this case. It really forces us to think about how a right that was written way back in the 18th century applies to the kinds of firearms we have today. You've got modern tech clashing head-on with historical interpretation. All right, so what kicked this whole thing off? Well, it all started when the Washington state legislature passed a new law. And this law went after a very specific and extremely common piece of firearm gear. The law zeroed in on what it defines as large capacity magazines, or LCMs for short. And almost immediately, a local gun dealer, Gator's Custom Guns, filed a lawsuit. They argued that banning any magazine that can hold more than 10 rounds was just a massive overreach, and that it violated the constitutional right to bear arms.
The case shot right up the legal ladder to the Washington Supreme Court, which in the end actually sided with the state and upheld the ban. But what's really fascinating here is the why. How did they justify their decision that this ban was, in fact, constitutional?
Okay, so the court's majority basically built their argument in 3 steps. First, they said, look, a high-capacity magazine isn't an arm on its own. It's just an accessory you attach to an arm. Then, they argued that these magazines aren't really necessary for self-defense, and that led them to their final point. If it's not essential, then the right to own one isn't automatically protected. That was their roadmap to upholding the ban. And this idea, this accessory argument, it's really the foundation of their entire decision. From the court's point of view, a gun can still fire a bullet without a high-capacity magazine, right? So to them, that makes the magazine just an optional extra, not a fundamental arm that gets constitutional protection.
But hold on, that wasn't the end of it. The ruling wasn't unanimous, not by a long shot. There was a really powerful dissent that came at this from a completely different direction, arguing that the majority got the law, the weapon, and the Constitution all wrong.
Yeah, and we're not talking about some small technical disagreement here. The dissent pretty much took a wrecking ball to the majority's entire framework.
I mean, look at this. The dissent, written by Justice Gordon MacLeod, comes out swinging. She argued that the very idea that someone would just, load bullets one by one into a semi-automatic firearm in a self-defense situation shows a profound misunderstanding of how these weapons are actually designed to function.
So what you end up with is this incredible situation. You've got 2 sides looking at the exact same facts, the same law, the same constitution, and they come to totally opposite conclusions. It's wild. Let's really break down where they split. Okay, this chart really lays it all out. On the question of whether these magazines are arms, the majority says, nope, just accessories. The dissent says, absolutely, they're essential for the gun to work as intended. On common use, the majority focuses on the average self-defense shooting, but the dissent just looks at how many millions of people own them. And this last one is huge. On history, the majority asks if the item itself has a long historical tradition. The dissent flips that completely and says, no, the government has to prove a long history of banning these kinds of items, and they argue it can't. Now, to back up their common use argument, the dissent pointed to data just like this. The key fact that an estimated half of all magazines owned by private citizens in the country hold more than 10 rounds. So their logic was pretty simple. If literally half the magazines out there are the kind you want to ban, well, how can we possibly say they aren't in common use? For the dissent, that was basically case closed. All right, so you had these 2 powerful, completely opposed arguments laid out on the table. Where did the chips fall? What was the final call? Well, in the end, it was the majority's accessory argument that won the day. The ban was upheld. Now, this sets a huge precedent in Washington state for sure, but it's really just one battle in a much, much larger war that's being fought in courtrooms all across the country over this exact issue. And that really brings us back to the fundamental challenge, right? The one this whole case puts under a microscope. When you have a constitutional right that was written with muskets in mind, how are our courts supposed to apply it to the incredible firearms technology we have today? As this case makes perfectly clear, even the sharpest legal minds can look at that same question and come away with 2 completely different answers.